This video will discuss the Australian case of Dow Jones and Gutnick, specifically the topics it addresses, which is jurisdiction and defamation, as well as the judgment made and its impact to Australia. Dow Jones and Gutnick is a landmark case because of the issue it had to resolve, which was whether Australian law could be applied in regards to internet content that is defamatory even if the content is subject to another country's law as well. So what's the story of this case? Well, Dow Jones the Appellant is a New York headquartered company where it publishes magazines as well as publishing it through an internet server in New Jersey, America, known as Barron's Online. The website Barron's Online gave internet access to content from Barron's hard copy magazines. During the 28th of October 2000, Barron's published an article about Joseph Gutnick, the respondent who was an Australian businessman. The article contains stories about Gutnick that would question his business property. In response, Joseph Gutnick sued Dow Jones in Australia because that was where he had his reputation to uphold, while alleging that the article defamed him there. So what was the main issue that the High Court was dealing with? Well, in this case, it was a question of whether Australian law had jurisdiction over the online defamatory material in regards to Gutnick. The High Court would need to figure out where exactly the article would be considered published for the purposes of defamation. In other words, was the article considered published where it was uploaded in New Jersey, America, or was it considered published where the content was accessed, specifically in Victoria, Australia, where Gutnick's business is centered in? If it was considered published when it was uploaded in the US, the High Court of Australia wouldn't be able to extend its jurisdiction to coincide with the US jurisdiction that handled defamation. It's important to note that the material must be accessed or communicated in a jurisdiction where the plaintiff has a reputation. This would mean that such defamatory would only happen if the plaintiff has a reputation there to begin with, while also meaning that one publication can potentially be subject to a range of different defamation laws, even if the plaintiff is no resident of that area. As such, the High Court's choice concluded that Australian jurisdiction is applicable due to the fact publication occurs when the content is accessed, because that is usually the place where the plaintiff has the relevant reputation unless proven otherwise. The reason why the court held that there was clear defamation in regards to the internet content was because it was clear that 400 Australians had already read the defamatory article, and since Victoria, Australia was Gutnick's main residence, along with his main business as well, it's clear that Gutnick has suffered harm to his reputation due to the defamatory article. Therefore, since the defamation happened where his reputation was relevant in Australia, Gutnick was entitled for compensation. So in conclusion, any publisher that published material that may potentially be defamatory may still be liable and be pursued in other jurisdictions where the harm has occurred. This case also makes it clear that Australia can establish its jurisdiction if an Australian resident suffers harm from online content, including content made outside Australia. Although most states in Australia have now passed defamation legislation that clarifies the question of jurisdiction, Dow Jones and Gutnick still remains relevant to the question of establishing jurisdiction online more generally.